You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Family Lawyer podcast. Today we have Vanda James, Tom Quinn, partners at Birketts Solicitors, and the topic of discussion today is looking at your experiences of out-of-court settlements, making sure we get the right results, looking at all of those, I was going to say alternative dispute resolution options, but we're now trying to make this a much more mainstream consideration. So my understanding is we're trying to drop the alternative moniker and use out-of-court settlement and that kind of language. It's great to have you both on the podcast to share your insights. So thank you very much indeed for joining.
Thank you, David.
Thank you for having us.
First question is very straightforward. Tom, in the first instance, perhaps you might give me a little bit of a synopsis of your background and your work, please, and then Vanda after Tom.
Sure. Okay, David, my name's, as you said, Tom Quinn. I'm a family lawyer and partner at Birketts. I head up our London family practice. I've been here for just over a couple of years now, and I set it up. So that was back in February 2022. Prior to then, I worked for many years at Phoenix Beach under Fiona Shackleton. I've been practicing now as a family lawyer, I think, since 2008. And I focus principally on finances between divorcing couples, also in children cases as well. Obviously, we do all children, private law children work, but that I don't tend to specialise in myself. I very much have a focus on the financial side of matters.
Thank you, Vanda.
Hi, so I'm Vanda James. I'm head of the family team in the Sevenoaks office at Birketts. I am relatively new to Birketts. I joined in November 2023, having come from Cripps, which is a top 100 firm based in Tunbridge Wells and London. So I have come across to set up a new family team in the Sevenoaks office. So it's a new office for us, having merged with Bachelors last April. And my aim is to build the team over the course of the next 2 to 3 years. I have been a trained collaborative lawyer since 2006, and very similar to Tom, really, do a lot of financial remedy work, but also some children work, relocation overseas, Schedule 1 applications, and similar things like that.
Really useful introduction. Thank you so much to the both of you. So the context of the conversation, as I say, looking at dispute resolution, what our options are, and really, I guess my first question to you and Vanda, perhaps you might take this one, is we should really be moving towards dispute resolution as not only a way to create better outcomes for clients, but also we have a responsibility to help ease some of the court backlogs.
Absolutely, we do. The court backlog is huge, worse in some areas than others. And I think dispute resolution, whether we're using the alternative moniker, is key to that because it's just much quicker, more efficient. So it will ease that backlog.
Tom, is there a risk here, though, that we're going to push people down the route of out-of-court resolution when actually a court resolution would be a better result or produce a better result?
A good question. I actually don't think so. Before you can ever get to having a trial, you have to have a financial dispute resolution hearing. You can either do that privately, and we tend to do them privately, and there's obviously a greater steer towards that now, or you can do it through the court, but you're not having a decision imposed on you. If one party is being completely unreasonable, then alternative dispute resolution isn't going to be imposed on them completely, save for arbitration, which I'll get to in a moment, because if you can't settle a case through these forms of dispute resolution, such as mediation or such as an FDR, then ultimately what happens is the case will rumble on to court. What we have now, though, is because we have such profound delays in the court system, we're starting to use more and more, and really we probably should have been using it before we have really, and that's arbitration, which is basically the same as with a private FDR, whereby you retain both parties, instruct a barrister to act or a retired judge to act as arbitrator, and you can just have that trial within a private setting. And so you still ultimately, that is where you get a decision imposed upon you by someone else where you aren't able to settle it directly. So I think it's fine, really, ultimately. I don't see any problem with it, frankly, no.
Perhaps this is an existential question, I don't know. And we'll come on to some of the changes to the family practice rules which have been implemented in April as well. Yeah. But is the culture of family law changing? Perhaps that's a slightly different way of asking the same question, where historically the first thing a family lawyer would think is to go down the route of court. Now the culture is changing in such a way that actually we're thinking of different ways to resolve this before we have to go down that route.
It definitely has changed. There's been a change anyway, but it's accelerated over the last, what should we say, since COVID, really, just with the way that the courts have increasingly struggled to deal with the weight of cases before them. What that means is it just equals huge and increasing delay, and it is really a worrying situation. Whilst there's been the introduction of new rules, and it's a product of that, by the way, so we really need to force you away from the court system. That's what they're doing, and that's fine. We've been doing it anyway. It will have an impact because I think from what I've seen, the movement to out-of-court routes of dealing with cases, of managing cases, was certainly started up in London, from my experience, sooner than it did in the provinces. But now it's everywhere. And that is a direct consequence of the struggles with the courts, the lack of funding, which is a more global economic issue, I think, for many institutions within the state.
Vanda, same question. Do you see that culture of law is changing? I mean, you described your background as coming from a big city firm. Is the culture changing in those sorts of organisations too?
I think the culture across family generally is changing. Even probably 5 years ago, we were seeing lots of cases going to court, but I think it's definitely accelerated over the last few years. And I think people are understanding that actually when a case is very acrimonious, it causes huge problems for the individuals. And gone are the days when, as a lawyer, you think, this is fantastic, I've achieved this fantastic result for a client. Actually, sometimes what you do is you cause destruction by being overly aggressive. And there are still lawyers out there, I think, that still practice like that. But I think, thankfully, with resolution membership and people understanding that there are consequences to dealing with cases adversarially, that actually have a detrimental impact on families and their children. And that's one of the huge benefits, I think, of ADR. So whether it's mediation or collaborative practice, in my experience, it enables couples to, even though they're separating and they're no longer married or civil partners or living together, it enables them to move forward, and particularly when there are children, to go forward and co-parent their children, because you're parents forever. You want to be able to go to your children's graduations. You want to be able to go to weddings and christenings and so forth, and there not be that hostility. And I think dealing with it in these alternative ways is a much better outcome for everybody, actually. And as a lawyer, I find it really rewarding, so much more rewarding than going to court.
You've both mentioned private FDRs as an increasingly popular route. I'm guessing the answer to the question as to whether they're a good thing or a bad thing is probably that they're a good thing. You're nodding along, but perhaps provide some context to that. I mean, why are we seeing them increase in popularity, Tom?
When we first started using them, the attraction was that you get a judge for the day booked out, and by that, when I say judge again, I mean a barrister who's jointly instructed by the parties. You have to pay a relatively small sum of money for them, so that's the additional cost you have. But you have them for the day. You have a private area, whether it's one of the law firm's offices or one of the barristers' chambers. You each have your own room, and then you have the main room where you go before the judge. It's really attractive in that way. You know that your judge will have read the papers. It's all taking place in this rather serene atmosphere, really. But contrast that to going to court, where the judges have a specific FDR day, I think it works out, and they will have probably several cases in their list. Will the judge have read a bundle of papers in full? No, almost certainly not. And that's no criticism of them. They simply won't have had the time. Is there therefore a chance that judge is not giving a considered view of the case? Yes, there is a risk of that. There's also a risk that you get bumped out of the list, or the judge simply doesn't end up having capacity to hear you at all. So those are the issues that you have. It's also in a court setting where you may not have your own private rooms, which is fair enough. It's all a bit frantic and frenetic. Add to that now the fact that the delays in getting a listing. So I'm talking about nowadays, and when I'm leaning towards now the lack of funding and the overburdened court system that we have now vis-a-vis, say, 10 years ago. You now have added to the mix the delay in having that FDR listed. It can be months away, and with a stronger risk of it coming out of the list. The only thing, it occurs to me, that we lose going down the private route, overall it's better on balance, definitely. I tell all my clients it's definitely better, is there is still a gravity to going to court and having a judge sit before two parties and saying, look, you really need to settle this. It's just a bit different to having a barrister do it in a private setting. It just is. And that's the only thing. So I think actually the one positive to going down the court route is I think there's almost a bit more pressure on the parties to settle than there is, say, in the private setting. It's a small distinction, and still on balance, I'm firmly of the view we've got no choice really nowadays but to use the private route because of the issues with the court system, I think. But that's the only thing that's the positive with going down the court route, I think.
I've certainly heard that point made, and I've also heard the point made that people like to have their day in court as well. Vanda, is that your experience? And then perhaps separately, how do you then identify the opportunities where a private FDR is going to be most appropriate?
I think it's got huge potential benefits, but it's not for every single case. So I think it's really important to know your client and at that first meeting with them, have a really in-depth conversation about all of the options available without leading them down a particular route. I've had a really positive experience of private FDRs. I think they're definitely the way to go in most cases. But as I say, they're not always suitable. You've got to consider those that are on a low income and just simply can't afford to have it. They have no choice but to go down the courtroom. Public funding has now been hugely reduced and is rarely available. Some people just don't have that luxury. And I think if we want to see it become the norm, then there's got to be some incentives from government to help people deal with it in that way. Obviously, there are cases that, as you say, people want their day in court. And there is more gravitas, I think, in a court environment. The difficulty is you could be waiting for up to a year, 15 months to get that decision. And during that time, people's lives are on hold. And people just need to get these issues resolved sooner rather than later, because by not doing so, I think it damages the family and the relationship generally. And so the speed at which you can have your private FDR is a huge factor. And actually, where it's now becoming more and more popular, there's a lot of availability for the choice of judge. And that's the other benefit with it. You get to choose your judge. Whereas if you go down the court system, you just don't know who you might get, whether they're going to have experience or not. So I think overall, they're really positive. And like Tom, I recommend to all of my clients, go down the private FDR route if we can, and you keep the court system as your last resort, as it should be.
You've highlighted the fact that funding has been decimated, and this is not necessarily the space to talk about that because we could be here for the rest of the day, never mind the rest of the week. But how then, and you talk about incentivising this in some way. There's the £500 contribution towards mediation that the government have launched, a voucher scheme which has been extended. Have you any thoughts about how it could be incentivised? Do you as a firm in some way incentivise it in any way?
In terms of us being able to incentivise it, I think what we do is we work with barristers who sit as private FDR judges that we know very well. And I think the indication from those, they want to do this work. They see the value in it. And I think from having a really good relationship with the barristers' chambers and people that sit as adjudicators, they will often reduce their fee and do it cheaper than they might necessarily otherwise. So I think it's about having a really good relationship, with your judges, the people that are sitting, getting some benefit and trying to get the fees at a sensible level so that it's not just the really wealthy people that can afford to do it. And I think in the grand scheme of things, it's not as expensive as some people might think. And also what you get with it is certainty, because you have your judge, you know they're going to have looked at the papers in great detail. Whereas you go to the court, you have a listing, and quite often you get a call the day before to say, sorry, we don't have a judge available for you. Or as Tom says, they've listed 4 or 5 at the same time. They're all effective, and quite simply, the judge just can't get through it all. And you've got a client that's left with still having to pay their barrister's fees, because brief fees are usually deemed a week in advance of a hearing. And when you get the call from the court the day before to say, sorry, we don't have a judge, what we now tend to do is rush around and try and find a private FDR judge, so that we try and save those barristers' fees and that they're not lost. And that happens quite a lot now, providing you've got somebody available at sort of 24 hours notice.
We're recording in the weeks after changes to family procedure rules, which are designed to encourage and to some extent incentivize out of court settlement. It's probably too soon to really understand whether they are going to work or not. And Tom, perhaps you could help me with a point of clarity here. My understanding is that the onus is really on the courts to push back as much as it is on you to be directing your clients towards mediation.
I think that's a nice way of summarising. Basically, what you've got to do now, if you're going to make an application for financial remedies, which is really to start the ball rolling for the court process, which I have to say we like to do anyway, because what you get back from the court when you do issue financial remedies is a court timetable. You've got to exchange a financial disclosure by a certain date, and you have your first appointments on a certain date. Now, it may be that all of that falls away because you're dealing with it consensually outside of the court system. But what it actually does, the great benefit of it is it does focus minds, because you can get one or other party who doesn't particularly want to focus on the divorce, or they're just burying their head in the sand. In the sand is probably a more apt way of putting it, because it's not a nice process. So there is a real risk of drift in all cases, either by one party or by both of them. So that's why we like to issue court proceedings without actually wanting to go to court. That's always a point I make. I routinely do it in my cases. The problem we have with that now is that you have to file at the outset of cases a statement that's called a Form FM5, which I've only looked at fleetingly. I haven't had to complete one yet, but you have to, within that document, explain whether or not you've tried out of court or non-court dispute resolution, and if so, why are you still issuing a court application? Or if you haven't completed non-court dispute resolution, why not? I know for a fact that's turning around to the court and saying, well, we want to get the court timetable in place, will not wash. I'm fairly certain that won't be, which is fair enough. I understand that. So that's where we are at the moment. It's very new, as you say. I haven't done it yet. It's quite an involved form. You have to really give quite considered answers. Will it have an impact? It definitely will have an impact, because what will happen is it will put pressure on the court. Well, if the court's not satisfied with that form, it's going to turf you away to go down the non-court dispute resolution scenarios. So I don't know that it will impact us, me and Vanda, enormously, because we're trying to do that anyway. My one concern with it is the risk of drift, because we can't get that court timetable in place, and then we might be struggling to focus someone on it. And the courts are going to be like, well, they may not be persuaded that that's really an issue yet. So I can see that being slightly problematic. But overall, I don't know that it's going to make, for me personally, I think generally, yeah, I think it will. I think it's going to serve the purpose that it's intended to have, which is to push more and more cases out of the court system.
I think the other point to mention about it is that it's not just before you issue proceedings that the court consider whether or not pushing it out to a non-court-based dispute resolution. The court has got to consider it at every stage. So what you could have is you could go through the initial process, get it issued in court, you could get to a first appointment, and you could find yourselves in a situation where the judge looks at it and says, well, actually, why are you here? The issues aren't that complex. This should be able to be resolved outside of court because the court time's very, and then they can, at that stage, and indeed at any subsequent stage in the proceedings, push you away and send you away to non-court dispute resolution methods. So it's an ongoing duty by the court. And certainly the intention is for it to have a huge impact on family cases. And so it should, really, because court should only be a last resort.
We're swiftly moving towards the end of the time that we have for the discussion. And I wanted to ask you both on your thoughts around what the Law Commission might or should come back with regards to their consultation on financial remedies. Crystal ball time. What would you do if you were in the Law Commission's shoes that would make financial remedies better for the client?
I have thought about this a lot. One thing I've always raged against, we don't have a situation where you can put forward without prejudice proposals and that there be consequences for not accepting them or accepting something close to them if you then end up going on to trial. Without prejudice, the court doesn't see this unless and until it comes to a final hearing and there's been an outcome, and then you can unveil effectively, like if 6 months before you put forward proposals on without prejudice basis that were broadly equivalent to what the judge ultimately decided, we'll just turn around to the other side and say, why on earth didn't you accept these proposals? Party A has incurred these costs since the date of those proposals, and I think you should pay them, or should pay a significant proportion of them. We don't have that. We have an open offer situation, but that's not quite the same thing. That's the big change I would put in place, because it would really focus everybody's minds, not just the parties, but the lawyers themselves. Everybody would be under more pressure to really think about what's a fair outcome here and advance a position as early as possible that sort of mirrors that. That's one of the changes. What I like about the law that we have is that it is very discretionary, which means that you should be able to get fairness in all scenarios. It doesn't always happen that way, but it should do. If we move away from this, which I think is possible, to having more prescriptive law, then you are going to sacrifice fairness in certain cases because it just won't apply fairly on all outcomes. So I don't know that I'd change it significantly.
I have a slightly different viewpoint, actually, and it comes from clients wanting certainty. And whilst there are benefits to having a discretionary system that other countries don't necessarily have, I think what that causes is uncertainty, and it can be sometimes tricky to predict the outcome of a case. And that will depend on your judge, which region the case is being heard in, because it does differ around the country. And I think what clients want and actually often need is certainty. So I'm in this dreadful situation. It's one of the most traumatic times of my life. What's the outcome going to be? And of course, we talk to them about Section 25 criteria and all of the things that the court take into account, etc., etc. And what we say is, as long as the judge comes up with, or your arbitrator or your adjudicator comes up with a decision that's within these bands of reasonableness, then it's okay. So it can be at the lower spectrum or it can be at the higher spectrum. So I think I'm not necessarily certain that the whole discretionary element should be abolished, but I think when looking at it, we could do something and make it just a little bit more certain for clients. So have some sort of more enshrined principles. The other aspect I think that the Law Commission are looking at is how maintenance payments should work for ex-spouses and ex-partners. And that's always a really interesting one. We've come away mainly from joint lives orders. It was one of the reasons why the UK was the most generous jurisdiction in Europe. So everybody came to the UK to have their cases heard, particularly if you were a wife looking for spousal maintenance. Our European counterparts have finite periods for maintenance and then it stops. And again, I'm not certain that we should completely lose the discretionary point, because no two individuals are the same. But I certainly think we could make some improvements so that clients just have a little bit more certainty and their expectations can be managed with that certainty at a much earlier stage, rather than waiting until you get all the way through the case and going to an adjudicator, whether it be in the private route or in the court system, and turning up and say, oh no, we've got this judge today. That might not be so good for us. It's just so random and unpredictable. Yeah. Your life in their hands, I think it's frightening.
Do I changed my mind slightly. I think we will reach a situation where there will be fixed or defined terms of maintenance, which may be referable, where there's not going to be a clean break, so there's sufficient capital to meet everybody's needs or whatever, that will go down the road of defined terms of maintenance, possibly referable to length of marriage. Whilst that won't be fair in all circumstances, removing uncertainty there will be enormously helpful to all clients. And I think that lack of fairness on occasion is a price worth paying for the certainty there, because it could be a total nightmare. Maintenance can be totally unpredictable, and it depends on the judge and that sort of thing, and it's discretionary but not necessarily fair anyway. I think that might be one of the outcomes that comes from what the Law Commission is doing, and on balance I think that's probably right. Actually,
you've touched on the Calderbank point, haven't you, Tom? I mean, in civil cases, you've got Part 36 offers, and they're a lot stricter. So Calderbank was abolished in April 2006, and I think it was a really useful tool. And then post 2006, obviously it's gone. They've come back with making open offers and so forth. But I've always felt that the family side of things is a lot softer than the civil side of things. And on the one hand, I agree that's right. However, sometimes I think it can be quite a weak system. And so when people don't do what they should be doing, because I think I saw a sea change when the Calderbank rules were abolished, I think I saw there was an increase in cases going to final hearing.
When I joined the profession, I couldn't understand it. And I don't know a single person that thought abolishing the Calderbank rule was a good idea. No, I don't know anybody that does. It led to people being able to adopt ridiculously unreasonable positions without having any fear of having a cost order made against them. Why should you have to put your best position on an open basis if you're going to end up going to court? I don't know that it's a just rule anyway necessarily. That's for a different time. And we've moved away from that a bit with this obligation to set out an open position. Why can't you do it on a without prejudice? It doesn't make sense to me. It still doesn't make sense to me.
I think we've been quite weak in family law in imposing cost orders over the years.
Yeah, that's the other thing that flows from it, which has changed as well. You can still get a judge, often a former children barrister or something, who is very reluctant to make cost orders. That's got to be wrong, because it's all part of focusing people's minds on settling a case reasonably.
What's clear is that we could end up talking about this for most of the rest of the day, but we have come to the end of the discussion and certainly the time that we have today for the podcast. It's been really interesting to hear your thoughts, not just on the nature of out-of-court settlement and the changing culture of family law, but also on some of those specific points around the changing regulations and what we might want the Law Commission to think about when they report on their financial remedies consultation. It's been fab to have you both on the podcast. Thank you so much for joining, Vanda.
Thank you for having us.
And thank you, Tom.
Thank you, David.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on todaysfamilylawyer.co.uk. My thanks to Vanda and to Tom. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.